The Federal High Court in Abuja has declined a request by the Department of State Services, DSS, to issue a bench warrant for the arrest of human rights activist and former presidential candidate of the African Action Congress, AAC, Omoyele Sowore, over his alleged failure to appear in court for arraignment. During Wednesday's sitting, the DSS, through its legal team, urged the court to authorize Sowore's immediate arrest, arguing that the activist had deliberately failed to appear to take his plea in a 5-count charge bordering on defamation and cybercrime. The prosecution claimed that the absence demonstrated a disregard for the judicial process and warranted coercive measures. However, in a firm ruling, Justice Mohammed Umar rejected the DSS's application, describing it as premature and procedurally irregular. The court held that before any arrest warrant could be issued, all defendants must first be properly served with the necessary court processes to ensure fair hearing and adherence to due process. The charges against Sowore stem from a post shared on his verified X, formerly Twitter, account on August 25, 2025, in which he allegedly referred to President Bola Tinubu as a criminal. The post was made shortly after President Tinubu's official visit to Brazil, where he reportedly claimed that his administration had successfully eradicated corruption in Nigeria. In response, the DSS alleged that Sowore's statement was false, malicious, and intended to incite public disorder, accusing him of deliberately seeking to provoke unrest and undermine the reputation of the president. The prosecution, led by Akinlolu Kehinde, SAN, maintained that the activist's remarks went beyond free expression and fell within the realm of criminal defamation and cyber harassment. The charges, duly signed by the Director of Public Prosecutions, DB, MB Abubakar, invoked Section 24(1) B of the Cybercrimes, Prohibition, Prevention, etc. Amendment Act 2024, as well as Sections 59 and 375 of the Criminal Code Act, in a development that underscores the widening legal implications of digital speech. X Corporation and Meta Platforms Inc., the parent company of Facebook, were also named as co-defendants in the suit, marked FHC ABG CR 484-2025. The inclusion of these multinational tech firms was based on their alleged role in hosting and distributing the purportedly defamatory content. According to the prosecution, the DSS had written to both companies requesting the temporary suspension of Sowore's accounts and the removal of the contentious post, but those requests were reportedly ignored. Justice Umar, in his ruling, noted that the bench warrant could not be granted, since X Corporation had not yet been formally served with a complete set of charged documents, even though it had received a hearing notice. The judge emphasized that the principles of fair hearing and procedural justice must be strictly observed before any coercive order is made against any party. Consequently, the court directed that all defendants, Sowore, X Corporation, and Meta Platforms Inc., be properly served with the relevant court documents. The matter was then adjourned until December 17, 2025 for formal arraignment and further hearing. One of the 5 counts filed before the court reads that you, Omoyele Sowore, adult, male, on or about the 25th day of August 2025, within the jurisdiction of this honorable court, did use your official X handle page, Omoyele Sowore, to send out a message tweet as follows: "This criminal, official, but actually went to Brazil to state that there is no more corruption under his regime in Nigeria. What audacity to lie, shamelessly, which you knew to be false, but posted for the purpose of causing a breakdown of law and order in the country, especially among individuals who hold divergent views on the personality of the President and Commander-in-Chief of the Armed Forces of the Federal Republic of Nigeria, Bola Tinubu, GCFR, and thereby committed an offense contrary to Section 24(1)(b) of the Cybercrimes, Prohibition, Prevention, etc. Amendment Act 2024. The ruling marks a significant moment in the ongoing legal confrontation between the state security apparatus and one of Nigeria's most outspoken critics of government policy. It also reignites the debate on the limits of free speech, the role of social media platforms in content moderation, and the use of cybercrime laws to regulate political expression in Nigeria's digital age.